Few Americans understand how administrative rulemaking and adjudication occur, even though they affect virtually every aspect of Americans' daily lives. Certain constitutional principles, such as the non-delegation doctrine, govern how agencies operate. We've previously examined how administrative agencies are creatures of statutes that define the agency's existence, jurisdiction, objectives, and processes. Another statute governing agency activities is the Administrative Procedure Act, commonly called the APA, or simply the Act. The APA has been called the Constitution of Federal Administrative Law because it lays out the broad structural framework and procedural requirements for most agency actions. Most federal agencies engage in two primary lawmaking functions: rulemaking and adjudication. Rulemaking is the process by which an agency creates enforceable legislative rules. Only legislative rules promulgated in compliance with the Act have the force and effect of law. Adjudication is the process leading to an order resolving a matter other than by rulemaking. Typically, but not always, it involves a dispute between private parties or between a party and the agency. It can be similar to a judicial proceeding, but it also includes processes such as licensing. Agencies may adopt new standards or rules in orders as well as in legislative rulemaking. The APA regulates both rulemaking and adjudication. Formal rulemaking involves an agency's consideration of a proposed rule in a trial-type adversarial hearing process. An agency official, usually an administrative law judge called an ALJ, presides over a formal hearing during which witnesses testify and evidence is introduced. Formal rulemaking is rare nowadays. Instead, agencies rely on informal rulemaking. The procedure requires agencies to publish a notice of proposed rulemaking in the Federal Register. The notice must cite the statute supporting the proposed rule and the proposal's actual language. The notice must contain pertinent information, including data, statistics, and studies supporting the proposed rule. The notice invites public comment and says where such comments should be directed.